We are having Mr. Vikram Hegde sir for this post-lunch session. Sir has been a dispute resolution lawyer. Sir has been a dispute resolution lawyer for more than a decade, and this time he has been representing clients whose profile ranges from daily wage workers, NGOs, political parties, and multinational corporate giants to government bodies. He also advises various bodies and associations on their constitutional rights. Several companies count on his counsel for their most important transactions. He is also a visiting faculty at NLSIU, Bangalore. In his session, he would be speaking on logistics and timelines for litigators. Vikram sir, I would now request you to please take over this stage and please bless us with your knowledge. Thank you, sir.
Audible? Is this working? Is it working? Am I audible? Or even if it's not working, am I still audible? Yes. Oh. See, I have two major challenges before me right now. One is that I have to meet the expectations set by the stalwart speakers who went before me over the last 2 days. The second, of course, is that speaking in the post-lunch session, I will also have to fight the lethargy that would have set in, the post-lunch stupor that would have set in, not only for me but also for all of you. But of course, I've seen that all of you are a lot more energetic, so I'm sure it won't be that much of a problem for you at least. So, logistics and timelines, just to give a broad overview of what this is going to be about. Of course, the entire session, the entire set of talks has been about what they don't teach you at law school. But to distill that a little more and to say what my talk is going to be about, it is not about the law itself, but things that are ancillary to the law, things that you need to know about and things that you need to be mindful of if you are going to be a practicing lawyer, especially a practicing litigator, right? These things would range from, say, arranging and managing your physical infrastructure to managing, of course, your time, right? These are some of the practical aspects of the practice of the law, which is necessary not only to get a good result in law, that is, not only should you end up with a legally favorable decision, but it also should give your client or the person you represent a relief in a meaningful time frame. The thing with our courts is that very often the litigation stretches on so long that by the time there is some sort of result, some decision by the court, it might have lost all meaning for the client. How do you ensure that it doesn't result in, your litigation doesn't result in that sort of situation? It should not be, to put it in medical terms, operation successful, patient dead. Right. Let's start with when you get a case, either directly from a client or maybe your senior assigns, the firm that you're working with assigns a file to you. How do you go about it? What are the logistical aspects to it and what are the time aspects of it? Logistically, first thing that you would be checking is the documents that have been assigned to you and identifying what is the nature of the case. If it is an easily identifiable remedy, for example, there are a lot of cases that come under very specialized legislations. If it is under the insolvency and bankruptcy code, that's a legislation that's fairly popular right now and fairly lucrative right now, I might add. Then you know what the remedy is going to be because there is a clearly defined tribunal that deals with these cases. If it's a telecom dispute, there is a clearly defined tribunal that deals with it. But there are a lot of cases where you would have to make a choice as to which tribunal would be the right one to go to. Disputes between a home buyer and a builder. This is something very common. You might have faced this in your families as well, where you would have tried to book a house and then the builder doesn't deliver on time. At present, there are several remedies. You can go to a consumer court, you can go before the specialized tribunal for it. Which is that? Does anyone know? Sorry? RERA, yeah. You can maybe initiate a criminal complaint against that person, against the builder, depending on what the problem that has been caused is. You take all these decisions, maybe in consultation with some of the other lawyers in the firm or with your senior or anyone else who would be in a position to guide you. But even to go and propose that this is the sort of action that needs to be taken, you need to have a sense of what is to be done. Once you have done that, and once you are delving deeper into the papers, you would want to check whether you have all the papers from the perspective of, if this is argued in court tomorrow, will these documents be sufficient to get a good order for my client? Very often, I see that lawyers who are fresh out of college, they have, even the good ones, they have very good research skills. They might even know how to draft very well. They might know how to frame their arguments very well. They do not think in terms of the documents that need to be relied upon to present the case in an effective manner. The image that they have of court as being reliant upon their arguments and contentions is perhaps a little different from what really takes place. The reliance of the court would primarily be upon the material that has been produced along with the petition or complaint or suit that has been filed, and less upon the arguments that you have raised in your petition. Of course, they will definitely look into the grounds that you have taken, and of course they will have an eye upon the prayer that you have ultimately made. But to get a sense of the real factual dispute, to get a sense of the real factual background, the first port of call of the court will be the documents that you have appended with your case. So to that end, and for that reason, you will have to be mindful of these things. There will also be situations where you will need a certified copy of a particular thing. And these are some of the things that you will look at when you are looking at the documents. Then, another important aspect is fees. I'm not talking about the lawyer's fees. I'm talking about the court fee that needs to be paid with the petition that you need to file. If it is a nominal sum, perhaps it is not such a big thing and you can do it as part of the filing without any preliminary preparation. But there are situations where this court fee is going to be a substantial amount, and at the very outset, even while you're preparing for the filing, this will be something that you need to prepare your client for, so that they can make the adequate arrangements to ensure that these court fees or the things that have to be made, that the fees that has to be paid to the court at the very outset is paid, right? Then you should also be mindful of the consequences of filing such a case or petition or suit. Whenever we file something in court, we are putting something down on paper. We are admitting that we know this and we are taking a particular stance. Does this close out some other right of mine? Is this putting me in a position where someone else might use this against me? Or is this putting me down an irreversible path from which there is no return? It might not be that this is a factor in many cases, but this is a mental process that you need to undergo. This is a question you should ask yourself before you embark upon the journey of initiating any litigation. Now coming to the timelines that will be involved at this stage of your work. When you start working on it, the first thing you should ask yourself is, how much time does the client have? The client wants a particular relief. They've come to you asking for some sort of remedy. In what time does this remedy have to be given to them? The outer limit over here is something that comes from a legislation known as the Limitation Act. That is the time limit by which you have to invoke whatever remedy that you're seeking to invoke. Otherwise, the law says you can't invoke that anymore. In certain circumstances, they may condone that delay, but by and large, your legal right is deemed to have ended once that period of time gets over. What does this mean? Let's say there is some right over some property that I am going to claim. Beyond 12 years, even if I had a right, I can't claim that. If there was some sort of appeal that had to be filed, a revision petition that had to be filed in the High Court, there will be a certain period of time that is prescribed. Under the special statutes, even apart from the Limitation Act, there will be some special time limit that is prescribed. A shorter time limit perhaps, with a view to ensure that legal proceedings don't go on forever. In all those situations, you are mindful of this time within which you need to file whatever you need to file. But like I said earlier, that is only the outer limit. The other question you should be asking yourself, and you should be asking your client, is when do you need this result by? Client will always say, jitne jaldi ho sake karwa do sir. But there are some genuine reasons where you will want to get that relief or get some temporary relief at least within a very short period of time. Maybe it involves a question of this person being evicted from their house being demolished, or even a question of this person will be arrested if something is not done by them. There may be a situation of something defamatory being published against me if some timely action is not taken. In all these situations, the time limit is not coming from the Limitation Act, but from the very practical need of your client. These things will be determinative of how much time you have to go and file your case and bring it up before the court. When we say that we have this much time, that of course becomes your new outer limit by which time you have to do it. Then you come to the question of how much time are you going to take to do what needs to be done. You know that you have to read a certain number of documents. You would have had a certain preliminary conference with your client. Maybe they need to do some other things. You have given them some homework to do, saying, okay, get me this other document. You go ask this other person what they are trying to do. You just check your records and see what you had done, and check your account and see what you have paid. Give me a summary of this. All of these things are things that you might be asking for. So after all of that, and you then factor in the time you need to do research, to do drafting, just see what else is on your table in terms of, I am also drafting 10 other cases. Will I be able to do this now? Or is it that only after I am done with that I will be able to take this up? Taking all these factors into consideration, you arrive at a time period within which you will be able to do it. You calculate that this is the amount of time that I need to prepare this case for filing. Practical advice, whatever amount you calculate that you need to prepare a case for filing, budget for double. You all submit research papers, right, as part of your course. How do you go about it? Do you usually finish it within the deadline? Or do you go to Professor Nagaraj or say, I want an extension? If you've ever gone and asked for an extension, you probably know that things usually take longer than you thought that they would take at the very outset. This is a very common problem, and I must admit that I very often fall victim to this problem, despite having gone through this so many times. And by now I should have known better. That said, this problem can be mitigated to some extent by proper planning. But I would not dare say that it can be eliminated altogether. But we can try and do better each time. Now, you have prepared your case and perhaps it's ready to be filed. At this stage, I will just take a detour and mention the distinction between what is taught in law school and what is not taught in law school. Perhaps what is taught in law school, all of, or at least most of what is taught in law school, has to do with what happens with your case after it's already before the court. After the court considers it, what is the likely result? Or during the time when they're considering it, what are the things that you can do if you're talking about procedural law? But there is a long gap between the time you file your case and it comes up before the court. As Mr. Gautam Narayan has previously spoken about, this might be a very short period in the High Court and maybe a longer period in the Supreme Court. But in both cases, or I would say in all courts, there is a fairly complex process that goes on in the registry between the time it gets filed and till the time it goes before the court. When I say it's a complex process, I mean that it goes through several levels of checking, through several hands, and there are a lot of things that you might not have thought of, which the registry will say is a reason to ensure, to stop your case from being put up before the court. If you had some urgent relief to be sought and you had some urgency, some immediate relief that you needed and it's not before the court, then there is a possibility that the whole point of filing the case is defeated. How do you ensure that this time is not more than what it needs to be? And mind you, even over here, you would need to budget for double the time or perhaps even more. But when you go about this process, it is important to have a sense of what are the typical things that the registry requires that you do not usually meet. It is useful in these situations to have clerical help, right? I can't imagine today a situation where I would do any of these processes without my clerk. Though only 5 years ago, I did not have a clerk and was doing all of this by myself. I know how painful it is, and therefore today I've given that up entirely to other people, right? Some of the things that you can plan for to mitigate the problems at the registry level, such as ensuring that the documents that you file, remember the first point we mentioned? Ensuring that the documents that you file are legible, they are in the language of the court. Some courts will insist that the documents be in English. Are they in the proper form, or is there some particular entity that needs to be part of this case which you haven't made them a party? Or is it that the court fees that we spoke about in the first part, is that adequately covered? All of these things are some typical reasons why a case after being filed can be stopped or will be delayed from going up to the court. You will also have to plan around holidays, right? As Sanjoy sir said in his talk, there are a lot of holidays of court. How do you ensure that you don't get your case, you don't lose out on arguing your case in a timely manner because there is a holiday? Or if there is a long vacation, is there a possibility of having your case listed before a vacation bench? Now, I'll just another detour, subplot over here. Now, vacations It used to be a happy time for junior lawyers or fresh lawyers. Not because we get to travel around or anything. That's the preserve of the senior counsel who will go travel to Europe or Mauritius or wherever. The junior lawyers are happy about the vacations because that is the time when all the other bigger lawyers are away, and that is when you might get to argue a case. A bigger case that you might not have got when all the other lawyers are there will still come to you because no other big lawyer is away. Right? So in that sense, vacations were a good time. But why do I say were? Why do I use past tense? Because these days I have seen that all the bigger lawyers, they'll go vacation in Mauritius, but they'll still appear by video conference. Even that one opportunity we had is gone. Right? Next question you will need to be asking. Perhaps this is a question you might need to ask even before you file it. But who are all the lawyers who are going to be involved in your case? You might ask me, the case has come to me, I am dealing with it. Why do I need other lawyers involved? There will be some legal reasons you will need other lawyers involved and some practical reasons you will need other lawyers involved. Legal reasons might be that the rules of the court mandate that you need a particular kind of lawyer to be filing this. I'm talking about myself, of course, that if you want to file a case in the Supreme Court and you're not an advocate on record yourself, you will need someone like me to sign off on the papers. And of course, I would do it only after satisfying myself that it meets certain standards. Right? There will be some other courts where they have a practice that you may be on record, you may be on wakalat, but you will need one local counsel. This is typical when, as Delhi lawyers we file cases in, say, Haryana. We will need one local lawyer to be on record along with us in those cases. It may also be a practical reason that when you are dealing with cases which are not in your primary area of practice, you would need one person to be there to handle any problems that come up from time to time, or even if your opponent needs to serve some papers on you, it will be more convenient if there is some lawyer available locally who's involved in the matter to serve papers upon or accept the service of those papers. For this reason, you might have to consider who these other lawyers involved in your case are. Then of course, you will have to think about whether you need a senior advocate in your matter. Who are senior advocates? You have one senior advocate over here, but who are senior advocates? Does anyone know? Who designates senior advocates? The High Court and the Supreme Court. So who are they? I heard a very interesting description of senior advocates in Allahabad High Court. You know what they call them? Or it's not that they're typically called that, but some clients call them that. They call them ulte gown wale. Because they have a flap on their back, and I suppose the clients thought that it's the usual lawyer's gown that's worn inside out. Right. So yeah, so who are these senior advocates?
There are certain qualifications and privileges where they don't need to file wakalatnama. They can just go and appear in any matter. So this is the privilege, and the thing is their seniority because of their experience and qualifications, and there are certain procedural qualifications also, income criteria and year of experience.
See, yes, there are various criteria, but in a broad sense, you could say that these are lawyers who are recognized by the court as of being of a certain standing above the rest of the lawyers. Now, when would you go to these senior advocates and when would you engage them in a case? Or when you're dealing with a case, how do you arrive at a decision as to do I engage a senior advocate to argue this matter or do I go argue it myself? See, I will start out with all the wrong reasons to engage a senior advocate, or all the bad reasons or the trivial reasons to engage a senior advocate, right? Some might think that this would be the only reason why I engage a senior advocate, but let's deal with these wrong reasons. First is the face value of the senior advocate. There would be a sense that they, being a senior advocate, they would have that status before court, and we want to capitalize upon that status to get a relief for our client. I would say that this is a trivial or the wrong reason to go to a senior advocate. There's another reason which is perhaps interrelated with this. Pardon my French, it's called what I would say the cover your backside approach. You know that your case has very high stakes involved. You do not want someone pointing fingers at you saying you did not do the best possible. So you say, let me put the responsibility for this on the shoulders of the senior advocate. So let's just say that, we did our best, we engaged the best senior possible, we tried everything, but this is the result. So no one should be able to point fingers at you, that's why you engage a senior advocate. Also a bad reason. There will be an even worse reason. There is a practice among lawyers because there is a sense that filing lawyers and junior lawyers don't get paid enough, as the client will not be willing to pay a substantial fee to the filing lawyer and the briefing lawyer. So there is this practice of, okay, let me go brief a senior lawyer and then have an arrangement with the senior lawyer where I will get a cut of his fees, because clients are very happy to pay large fees to senior lawyers, senior advocates, right? So also a very bad reason to engage a senior advocate. Now let me come to the good reasons to engage a senior advocate. Now, as we said earlier, senior advocates are those who have been recognized by the courts and for their expertise, for their standing and for their experience. Now this expertise and experience means that they have a certain depth of knowledge which will give you some better guidance in the case that you're dealing with. It also means that they will be, thanks to their larger experience, they will be able to ensure that you, as a lawyer who's been dealing with this case, are not missing the wood for the trees. Maybe as a lawyer who has been dealing with the nitty-gritties of the case, you are so caught up with the details that you're missing the larger picture. A senior advocate will be able to guide you on this. Thanks to their experience, they will be able to, as Winston Churchill puts it, see further into the future. Those who can look further into the past can look further into the future. Maybe they are able to better predict where a particular litigation will go, what will be the outcome, what will be the eventual thing that happens in this litigation if we take a particular route at this stage, at the inception. That is a good reason to go to a senior advocate. There is another angle over here. I'll just talk about my own past over here. For 5 years, I practiced in trial courts and then in the High Court of Karnataka. And then in 2015, I shifted to Delhi where I started practicing in the Supreme Court. First with a very senior advocate. That is when I realized the significant shift in perspective from the trial courts and the high courts to practice in the Supreme Court. When I was practicing in the trial court and the high courts, my perspective of preparing for a case was this. On preparation on the law was this, that I would read all the barracks, I would read all the black letter law involved, I would do a thorough research of the case law on the point, I would read the commentaries and see what all has been decided, what is the law that is there today, and that would be my comprehensive research on the point. What more can there be, I thought. I was not aware, or being a, as they say, Kupamanduk, I did not know that there could be more than this. When I shifted to the Supreme Court, there was opportunity. Then I saw that there can indeed be more. What is it? What is this change in perspective? The Supreme Court, you will find, is the court that has laid down the law, and therefore it is the Supreme Court that can also change the law. And if it is the Supreme Court that can change the law, and you are arguing before the Supreme Court, you now have the opportunity to convince a court to change the law. And if that is the case, your entire research that when I was in the High Court and trial courts, I thought was the end of my research, I find that this is the starting point of my research. What should the law be is also a thing that you can think of. And in these sorts of situations, you will benefit from the able guidance of a senior advocate who will be able to tell you not just what the law is, but also what the law ought to be. And this is one of the reasons, or this is one of the situations where you would want to engage a senior advocate. Then we come to the question of when do you engage a senior advocate? Easy answer, when the client is willing to pay for it. But even if a client is willing to pay for it, don't engage a senior advocate for some trivial thing that you can handle yourself. Take a senior advocate or engage a senior advocate to argue for you where it really matters. Where there really is some consequence. Right? How do you then go about your hearings? I am not going to get into the details of how you argue and the details of courtcraft, but for the purpose of the question of timelines, I will go into some basic things that you need to do or be mindful of when you go into each hearing. First is the question of anticipation of what is likely to happen versus what you want to happen in a particular hearing. It may be that in a lot of circumstances, it is a simple adjournment that might take place. And maybe that adjournment isn't hurting you today, but you don't want too many of these to stack up and your case to go on forever. And you should be precisely aware of what stage is your case at, what exactly is happening, and how is it going to play out. That is one bit of anticipation that you need to do. In some of the courts, you have something called an office report. That what is the case set up for now? What is the thing that is for consideration of the court at this hearing? You can also get an idea of this by looking at the previous orders that have been passed. And of course, if you have been engaged in the matter, you would, by virtue of having been part of the case for a long time, you would know what exactly is expected to happen. This leads us to the next point of preparation for each hearing. You know that you need a certain order from the court, and how do you prepare for it? Again, I am not going to talk about the on merits preparation. I am not going to say that you should do your research. That goes without saying. I am saying that you should ensure that there is no procedural reason why your case gets adjourned or gets sidetracked and goes off into some other tangent other than what you want. This also means that you should be mindful of the fact when you have a larger goal, when you have a particular result you want, you should be careful to not let the proceedings get sidetracked from that main goal by some other trivial request that you have made the court, by some other procedural thing that you are asking for, or maybe even some sort of interim relief and let the whole proceedings get hijacked by that one thing which has got nothing to do or which deviates from what you ultimately wanted from the court. This brings us to the aspect of craft. Now, this is something that the senior advocates are really good at, and something we really should learn from them, and we should also adopt if possible. How do you ensure that your hearing does not go wasted, doesn't get deviated, does not become another of those things where nothing really transpires? Unless, of course, you want nothing to transpire. Don't do it. Right? Now, there will, of course, be ways to ensure that the hearings go on. To give you one example of how a senior advocate might ensure that a case goes on or gets adjourned as they may want. If they really want an adjournment, it does not behoove a senior advocate to go and ask for an adjournment. It's only for junior lawyers to go and say that, okay, I want some time. Senior lawyers will have another way of going about it. They will say, my lord, this needs to be heard, this needs to be argued. So when a senior advocate says, yeah, this needs to be argued, it means that it's something really important and will go on for a long time. And courts are always very busy. And the call they will take is, all right, yeah, this is something that really needs to be heard. So perhaps on some other day, because today I'm very busy. Not thinking of the fact that on that other day also they will be very busy, because there is never a day when they aren't. If a senior advocate wants something to be heard, they will not say that this is very important, I am going to argue for an hour, because they know that the court is busy. And if they reveal that they are going to go on for hours, the court might not entertain. They will start with, it's a small issue, only 5 minutes. A short point is involved in this, and then they will take an hour. No court dares stop the court. Right? So these are aspects of craft. I am just giving you an example of, don't try this at home. Right? Now, another thing, one of you had asked about this in one of the previous sessions. How do you manage between different hearings, between different courts, different hearings? Even before I get to answering the how of it, let me put this in context by saying that, you see, this is a problem of plenty, right? There, in the early years, I have gone years without having, without ever having to deal with this problem of multiple hearings on the same day. If I have 2 hearings on a day, then it's a busy day for me. That was the situation at some point. Then, of course, when the VC hearing started, we got too comfortable and said that, okay, I will take on as many cases as I want, because I don't really have to physically run around. So I can be in as many places at the same time without really stressing myself out too much. And that has now resulted in a situation where, this is a hard question to be answered. Planning, scheduling are all some answers, but they may not be 100% answer. Persistence from other lawyers is definitely an answer. And that is where perhaps as younger lawyers, your opportunity comes up. As a junior lawyer assisting a senior lawyer, the thing that you should be secretly praying for is, let my senior get caught on his legs in some other court and we get an opportunity to make some submission. Though of course, again, that might not work in every case, right? It is a problem that is certainly made more manageable by the VC courts. And while the merits and demerits of VC arguments by video conference are debatable, this is definitely one of the merits. While on the point of VCs, let me come to my next subheading, that is the use of technology. See, there is, in our profession, there is an inherent resistance to the adoption of technology. When I was a law student, there used to be some sort of sense that research online doesn't really give you the sort of results that you want. And there was some sort of complaint that the law students today and the younger lawyers today are relying solely upon, say, SEC Online or Manupatra, and they don't really know things. This criticism is not entirely wrong, but you have to understand it from the perspective of the fact that when we utilize these technologies, what are we using this for? And this is a criticism of technology in general, in a sense. Back in the Industrial Revolution also, they said they painted technology as labor-saving devices. In a sense, it is a good thing. But don't think of these as labor-saving devices. Think of these as efficiency-increasing devices. Don't think of, say, SEC Online or Manupatra as a replacement to your usual modes of research of reading a commentary or going into some similarly decided cases and seeing what has been done. Use this as a way to reduce the time that you typically take to do the sort of research that you might do. And while I am giving the examples of research, don't limit yourself to it. Recently, I saw this artificial intelligence program that is doing the rounds on social media called ChatGPT, which is scary. They give some sort of, you give it a few bullet points and it comes out with a draft that could rival any lawyer. GPT-3 is called. Yeah. So there are all these new technologies that are coming up. There are two things to keep in mind when you deal with these. It's not a replacement, right? It's not a replacement. As they say, artificial intelligence is not going to replace lawyers. But lawyers who use technology will replace lawyers who don't. How do you ensure that this technology becomes an aid, a help in you being a better lawyer? There are, again, two ways in which you should look at it. One, examine and understand the technology for what it is. This is an easy thing to do. We check out a new app, we see all its features, we maybe even note down, okay, this is the sort of thing I can do with it, or this is what I will utilize it for. To what extent do I, is it a paid app? Do I have to spend money on it? All of these things you can consider and decide, understand the technology. This is the easy part. And the technology these days is, they work hard at making it easy to understand. There is a more difficult process involved here. What is that? Whenever you're interacting with technology that is meant to mimic your mental process, you should have a very good understanding of yourself, of your own mental process. As a lawyer, what is your train of thought? What are the things that you think of? You need to have that kind of metacognition. Not only do you need to know things, you should also know what you know and know how you know and how your mind processes these things. When you have a very clear understanding of how your own mind works, you will be able to very easily identify what part of your mental process is not being replaced by that technology, and where is it that you can do really better than that technology. Second, you will be able to demarcate what part of your mental process is being adequately mimicked by that technology, which you can now outsource to that technology, right? I'm not talking about this in the context of the prevalent artificial intelligence, because it's perhaps meaningless. That technology will keep changing. This is a general principle to deal with technology overall. It from my side about the stated topic of logistics and timelines in litigation. But I would also like to talk about some of the questions that had been coming up over the last 2 days, not just in the sessions, but even outside of the sessions when we interacted with students in various places. First, the fears of being a first generation practitioner. And of course, as in you've already been given some amount of succor by our assurance that it's not really that bad, I will give you a couple of ways to think about it, which will, I hope, give you some more reassurance about being a first generation lawyer. See, we think when we say that we are a first generation lawyer, we are perhaps thinking of it only in our own terms. Look at the country as a whole. If you think you are a first generation lawyer, think about the crores and crores of first generation litigants who are out there who don't have access to a lawyer. If there is a lawyer who has had many generations of lawyering in their family, they are perhaps not even the most well-known lawyer in their family. You, as a first generation lawyer, are the only lawyer in your circles, and you're the only person that your entire group of friends and family can go to should they need some sort of legal assistance, right? In that sense, when you look at it from the perspective of law as a public service, you know that your opportunity to serve people is much more. You have the opportunity to be of assistance to someone who really needs it, to someone who doesn't really have another person they can go to. And I would argue that that is an opportunity that first generation lawyers have. Then a lot of you have had this question of where should I practice and why should I not practice, let's say, in a particular place, in a city somewhere where there are perhaps more lucrative opportunities. While once again we say that you should ensure that you can be a big lawyer in a place where there aren't any other big lawyers as well, but let me give you a perspective of why that might work and how it might work and what might be a good path. As I mentioned earlier, I started out in Mysore. I'm from a place called Sirsi in Karnataka, but I did my schooling in Mysore and I started out in Mysore, and shortly thereafter I shifted to Bangalore. And for 5 years I practiced over there. In 2015, after having practiced in Karnataka in the trial courts and then later in the High Court for 5 years, I then shifted my practice to the Supreme Court. Is it a thing? Was this an idea that I would do better in the Supreme Court? See, that was not really the motivation, but I'll tell you how my stint over there has helped me. The knowledge that you gain from working in the trial courts is definitely beneficial, and everyone will tell you that. There is another way in which my experience in the trial courts and in the High Court has helped me immensely. Today, in the Supreme Court, most of my practice, most of my cases come from Karnataka, from people who saw me working in the trial courts and in the Supreme Court, and people who knew that they could trust me with their case when it goes up to the Supreme Court, right? Supreme Court, all cases, or a lot of cases which start out in the trial courts will eventually end up in the Supreme Court. And if the people who have seen your work in the trial court can rely upon you for it, for representation in the Supreme Court, and you have established yourself or you have made a name for yourself in the trial courts and in the High Courts, your practice in the Supreme Court will definitely be better off for it. Now, a lot is said about people requiring some sort of trial court practice before they move to the appellate courts. I have another view on this. I think the lawyers who practice in the trial courts should have some appellate court experience. We in the appellate courts very often think that this case was spoiled at the very instance by someone who didn't think of all these things. That is because perhaps the person who's dealing with it at the trial court has never thought of what might happen 10 years down the line. Now it is only if you have some sense of what goes on in the appellate courts that you will be able to practice well, you will be able to think, you will be able to foresee what is likely to happen 10 years down the line when this litigation finally goes up to the appellate courts. And while I have done the reverse journey, I know of people who have practiced in the appellate courts and have then gone back to their hometowns, to district courts, and are doing really well for themselves. So don't rule out any of this, and both are equally valid. Or you want to just go somewhere and try out things, it's not bad at all. Know that it's not bad to start out wherever you can and then think about where you can go with it, right? And then a word about what you learn, and perhaps it's a little blasphemous to be coming to a law school and saying don't learn the law, but that is precisely what I would say. But I will qualify it by saying that don't learn about the law in silos, don't learn about this particular act, this particular provision, this particular case law and think that you're done with it. When you are learning these things, think about and start observing the patterns in the law, the general trend that you see across areas of law. Also start developing skills that are necessary to get into that mode of lawyering. The legal thought process, the legal reasoning process is something that you should focus upon. Learn skills that you will be able to employ as a lawyer. And why do I say this? Because the law in silos, it keeps changing. You think that you have read this much and you are an expert today, that your expertise is going to be short-lived because the law will change. If you are mentally agile, mentally able to keep learning things, then you will be able to deal with any changes in the law as they come up. So, yes, so as Oliver Wendell Holmes says, the life of the law has not been logic, it has been experience. And if that is what we say about the law, it is certainly what we can say about practicing law. And I certainly have enjoyed thoroughly listening to the stellar speakers who have spoken before me and benefiting from their experience. And I hope that all of you have as well. Right? With that, I will conclude. Thank you.
I'm sure, sir, a lot of the students have questions, but due to the paucity of the time and since our guest has a scheduled flight, would like to move on to the part. I would.
You're scared if you put up with us another day?
We'll be happy to have you, sir, for another day, but it's about you, sir. We are working according to you, sir. So I would like to invite Professor Yogesh Pratap Singh first, sir, for
words of motivation.
For words of motivation to the session.
Thank you very much for inviting me and giving me this opportunity to meet all the lawyers from various parts of the country who gave you the practical insights as students, we are a common law country. So, and one of the features of common law country is that justice should not only be done, it must seem to be done. And because of this tradition which we have inherited from British, we ended up with codes like, procedural codes like CPC, CRPC, Indian Evidence Act, because we emphasize more on procedural aspects rather than substantive law. So if you go and see the functioning of the courts, whether it is trial court, whether it is high court, or it is the apex court, Supreme Court, lawyers are more engaged with procedural justice. So IPC, Indian Contract Act, law of tort comes later, but you must have mastery over the procedural law. And what you study in the law school, it is also kind of irony that in law schools now we have confined these procedural laws to, so IPC we teach in 2 papers, IPC 1 criminal law 1, criminal law 2, but CRPC 1 paper and CPC 1 paper and Indian Evidence Act 1 paper. So studying CPC, CRPC and evidence in 1 paper, I find it very, very difficult. It is impossible to comprehend CPC. I used to get in my university, Allahabad University, I used to get a lawyer from Allahabad High Court and Trial Court who used to come and teach CPC. At that time I did not realize why lawyer is coming and taking classes in the CPC and evidence. So I think law schools have now realized that we have to focus more on procedural law rather than substantive law, because when you go to the court you find handicap. We are not equipped with much information how courts are functioning. IPC you know, but IPC comes later. First you know CPC, CRPC and Evidence Act and Supreme Court rules and High Court rules. You have to have command over these rules and these tricks. What we have studied in law school, you find that it is of very less relevance. So I think this kind of sessions are very, very important. I heard Vikram, I heard in client counseling competition, the kind of inputs he was giving, it is possible only with the lawyers. So this is a very unique program which I think Jabalpur Law School, the student body has conceived, and this kind of program should happen regularly. I wish you good luck. Thank you very much for giving me this opportunity.
I would like to thank Professor Yogesh Pratap Singh sir for the kind balance they have drawn between the professors of the law and the practicing lawyer. Now I would like to invite Rishabh Gupta sir for the valedictory session.
Thank you, sir. Thank you everyone present here. For this valedictory session, I would like to extend my sincere thanks to our Radiant Art Club, which is also present here, which is called Rang Saas, for the elegant paintings which we have now Art Club has prepared as a token of memento. They have put their creative minds into for our honorable guests who have given their precious time, because if time is money, then today you have spent millions for us. Thank you all for making this event successful. Now I would like to invite our Dean of Academics, Dean of Faculty, Dr. Manvin Kumar Tiwari sir, to felicitate our esteemed guest Sanjay Ghosh sir. Manvin sir.